Good afternoon. Okay, so due to situation, instead of I was supposed to say good morning, but doesn't matter as long as it is good to the morning or evening, really doesn't matter. Okay. So we are here for the next 1 hour or so to discuss on certain aspects which our MC has just highlighted. Before we start on, we have had enough of introduction, enough of stage setting, breaking the ice, so maybe it's not that much required. See, as the AI system is increasingly evolving, we are facing with certain challenges. Some of them have been discussed, some of them has been pointed out, and we will try to discuss that in depth in today's panel. So this panel invites some of those in a deeper examination, and to do all that, we have three wonderful people with us. Okay, we are supposed to have one more panelist who had other priority and could not make it. So I have Sumod Kumar from TCS. We have Shivani from Stratify, and we have Karishma Patel from IB Merchants. I'm not going to read their bios out, they're in your small little bag which we gave you. And so let's get on to the business. Now, before we get really into the depth, I would request each of you for some of your introductory comments on this topic. So, why don't we start?
Thanks, Professor Anandya, and thank you for inviting me today. It's a pleasure to be here. And as it was introduced, as the topic was introduced, you could sense the importance and relevance of AI in today's business scenario, and therefore, with the need and the business requirement comes the complexities of commercial legal complexities. So a lot of important questions have been today put forward, which requires introspection. And we have a very good mix of technology, legal, and people with a very good commercial background as well. And I feel the session today and the topic today is really looking at how we could articulate the interplay of intellectual property, computation, regulation, understanding the depth of AI pipeline, and primarily addressing a commercially viable and legally defensive subject matters. I think that is what I am looking for, and I am sure Professor Anandya, with his depth and expertise, would prompt such very important questions, and we also look forward to take it back as a key takeaway would be this very collaborative interface and the complexities which we should understand and clear before we leave the room. That's all from my side.
Hello everyone. Thank you for the organizers. I'll just start with the introduction. I'm Shivani. I'm an engineer turned lawyer with a background in data science and also a consultant for DPDP. So my side here is more for the data, because when we are talking about AI, data has to be backed up. So I was very happy when Raka mentioned about it. So I'll be talking about how we are AI ownership, and then how it cannot be we cannot mention about data being a part of it. So yeah, that's all about me, and I think I'll just pass.
Hello everyone, I am Advocate Krishna Patel. I am a partner at IB Merchant and Company. I have been driving the non-litigation department for my company since past 12 plus years in the field of IPR, IT data and pharma. Lately, with the DPDP also getting notified, there has been all of a sudden an entire stream of companies that are now wanting to take data seriously, which actually being Indian companies, we always last in this scenario. It's only when our companies have target audiences in Europe or US, that's when they used to get very alarmed about the fact that, okay, we need to be GDPR oriented, we need to have the privacy policies in place for that country specific. But it's now very interesting to know that now even Indian companies are wanting their companies to have their data protected under the Indian laws. That's thanks to the changes in time. So I'm sure as the panel goes by, we will realize the role of the government also playing in every country when it comes to AI and data coming in. So thank you once again to the organizers for giving us this opportunity. Thank you so much.
So let's get into the depth and try to do a little deep dive. So my first question to my good friend Subodh, when we look at a typical scenario where, let's look at an AI pipeline where one party controls, another party makes the models or the algorithm, and the third party integrates the system. This is more or less very common system how the business is running. In such a situation, what is the most defensible way of ownership allocation? When I mean by ownership, it's who owns it and who controls it. What are your views on it?
The question is legally defensible, but I would also add one important component, commercially viable also, because as you have rightly expressed, the AI pipeline has a variety of stakeholders. There's a lot of variety, but then for simplicity, let me put it into certain few understandable compartments for better understanding. Of course, A, one who creates the data. B, one who uses the data and who is the owner of a model, AI model, and trains the model to perform a specific task. And then you have an integrator who would utilize the data, the model, and bring in a lot of applications, wrappers, and layers because his customer wants that. Okay, so he's the one who is integrating all this to meet a customer requirement, and typically organization like TCS, we play that very important role of being able to make that very orchestrate, I would say, between who creates the data, who owns the model and trains the model, and finally how we build a very commercially viable solution and product which customer takes. See, the straightforward answer would be that yes, there cannot be a single ownership. It's quite obvious. Okay. But having said that, what is that? If it is not a single ownership, how do we go about? Like, for the better understanding of everyone here, let me again try to put it in some understandable components. A, the data creator or who owns the data, definitely his interest would be that whatever data I have created, whether it is an experimental data or any kind of data, that I being the creator, I need an ownership. Okay, so that's the first premise and understanding and his requirements. Second comes the models, and AI models are not easy. Okay, today even the big techies in India have to rely on AI models from different other geographies also. So when it comes to model, whereas data can be sovereign and geography specific, but when it comes to model, you have to have that openness to look at the best model which suits, and it could be in any country from where you have to get those models and work with. But then, will a model and a data together be sufficient? No. There must be some layer of training. And training doesn't mean that data is inputted into the model and the model brings out a brilliant answer. It's not like that. So there has to be a lot of weightages, validations, etc., to make the model really work and train. So there is that training layer. Then comes, with all this in place, somebody like me who is working for a customer wants to build a solution. And what a customer is not interested to see what is behind. He wants a front-ending solution which addresses his bottom line, be it cost, profitability, operational efficiency, or anything, or analytical requirements or whatever. So when you build that wrappers and layers, I also need to build in a lot of applications. So look at the various layers of intellectual property which gets created. Data is one intellectual property. Model, the architecture of the model is another. So the person who has built the model would like to hold his IP on the architecture and the layout, and also he would also say, look, my model is there and you have given me the data, but it is me who has worked that data effectively with my model to come out with some technically desirable solutions. And the solution provider and the wrapper, like the IT companies here, would have built a lot of wireframes, and they would have built a lot of application layers, so on and so forth. So when it comes to this level of pipeline and this level of IP creation, so the ownership is pretty much clear. It cannot be a single ownership and an ultimate ownership. Having said that, it would also require, like from a data creator point of view, okay, yes, I would allow the model to use, but I want to restrict the usage as well. So there could be those kind of layers. Whereas the architecture of the model person who owns the model would like to, as I said my earlier argument, it's not just data, but data was something. So in net, while we can have, say for example, a data being protected by a trade secret or any other relevant data protection laws, an architecture could fall under other forms of IP, a copyright or a patent. Then comes the application layer, which will also go through, but net, each type of IP would require the suitable form of IP protection, and it has to be jurisdiction specific but all the more important is how do you orchestrate the entire players and make a commercial viable. That's where the contractual law comes into play, where very important for all the players to come into an understanding what is my background IP, and when I get into a contract, the eventual IP which comes out, who owns. So that decision and that contractual contours are very important, and also between all these layers there must be a viable model where, because it's not that I build a solution and give it. Tomorrow there may be a problem with the data, or there could be a problem with the wrapper, or it could be anywhere. So there has to be a licenses for each other to be able to come, audit, change, and even use it. Okay, so this kind of interplay of licenses also becomes very important in contractual framework. And more so, there are instances when you look at a lot of litigations which are happening, there are proprietary data versus customer specific data. Especially it becomes complex when customer gives you the data. So you'll have to be very clear, while you have orchestrated a model, you should also look at the legal boundaries that look, this is a customer specific information, so what kind of safeguards I need to do, and what is the contractual freedom I have to be able to use it for other customers. So these are some, I would say, I just vetted out few points, but it's more complex than I can describe, but let's get into the other discussions to bring more clarity into the subject.
Thanks, Shubhu. That was quite a satisfying explanation. Okay, so what we look into here is that before you jump into the project and to join hands, let's agree everything contractually, and make it clear about the reps and warranties and the liabilities, etc. That will make life more comfortable. Okay, fine. A follow-up question to you, Shivani. On the same line, see, we understood that for any joint work, it's better to have a predefined contract which has a predefined, articulation for the IP terms. But when multiple parties, that, like the case we are talking about, develop a kind of foundation model, what should be the contractual agreement? How much should it depart from the default IP rules when it looks into, let's say, joint opposite, inventorship tests, or maybe unity of title or something like that? What are your views on that?
So yeah, first of all, I would agree to what Subodh mentioned, that of course it should be decided based on the contracts.
You're right?
Yeah. Yeah, so I was saying that it is important to have everything mentioned in the contract before getting into even involving in AI modeling and everything. With the right now how the companies work, of course they have multiple parties involved. So this thing should be decided. I would also like to talk about when we are deciding the ownership of the the data, the model, the fine tuning, but it should not restrict further innovation also. So somewhere in the contract it should be mentioned that further innovations can also be, I don't know, maybe it should be decided that particularly. Also, I would also, so once the ownership and everything is decided, now talking about the data, the responsibility also comes in. Because if something tomorrow happens related to DPDP coming in the picture, then which of the ownership people involved in the contract should take that responsibility if any breach happens? The data person, the model making person, the fine tuning person, I don't know, so that should also be particularly decided, I believe. So contracts are the best way of having this decide before even getting into the business. That's what my.
Just a small, you made a very, very, important statement that whatever you do in the contract, further innovation should not be stopped.
Yeah.
On that aspect, I'll go back to what Subodh said, that we start with a lot of background IP, work together, and come out what we call as foreground IP. So these are the terms we normally use in contracts. Now, there should be a clear-cut understanding on the ownership of the forward IP to enable everybody that they can further use it and innovate it.
Yes, I think there should be.
What is the actual situation? Is there, sometimes the reality, I'm supposed to be a nice person, but I'm not. Okay, so the contract should be that, but sometimes, the business does not happen that way.
Yeah. As I told you, so on that lines, I would like to mention recently there was a incident about Anthropic and Alibaba. So we are now talking about the model ownership, data ownership, but they actually alleged Alibaba that they are distillation of their model behavior. They have distilled all of that, and so we are still in a very, I think, very, very earlier stage of that discussion of the ownership part. People are now alleging that AI behavior is also being copied right now. So I think for that also some kind of that the model's outcome should also have certain kind of ownership, or that behavior or that kind of cannot be copied. Something like that IP should be given for that. Something like I feel, because we are in the very, very early stage of discussions about that, but I think that should also be considered.
I totally agree. We are probably in a state of infancy now.
Yeah.
And we await to get more and more mature as the day comes on. and then technology will always take the role, because law is always a follower. Let's get that clear. It's a technology which is the forerunner. You cannot have a set of law or a statute ready for tomorrow's technology. Law is going to follow the technology trends, and then often, because in the digital age things are moving so fast, it won't be wrong to say that law is actually struggling sometimes to keep pace with the developments. Having said that, let me come to you, Krishna, that in this scenarios, where we see an IP value chain being built, it may be whatever, a cloud computing or a foundation model, or any proprietary data set, or maybe some kind of tool. What are the most problematic dependencies one faces?
So I wouldn't actually say that there is one single layer which is causing the major dependency issue. It is basically a concentration of concern throughout the entire value chain of AI. That is your compute, your models, your data. It is all on the basis of the risk each of these value chains are generating. When it comes to your compute or cloud infrastructure, the major dependency that currently we are facing is that for making a compute infrastructure, you need computational resources, you need high performance chips, you need that sort of an infrastructure. And current scenario, there are only few global players in the market who is actually having all of these accesses together. So that makes dependency one more issue in that layer. Then you have your foundational models that are there. What is happening is that majorly you have products that the companies are making, but those products are being made on a smaller frontier models, which again those frontier models are owned by only certain specific global players. What happens if anything goes wrong from that perspective? You have tomorrow license agreements changing on those bases, they increase the pricing, as Shivani pointed out, your model behavior issues that come in. So again, the dependency increases therein. Then you have data, which is of course the king today. Besides proprietary data, you have the personal data also that is of finance perspective. You have pharmaceutical perspective data that comes in. How to navigate those data, again, the dependency increases. The only in the value chain, the least dependency I would say is the tooling factor. Because tooling is something that eventually can be replaced. So when it comes to the value chain, that's when I would not say one dependency. It's dependency on all currently. So yes.
Thanks a lot, Krishna. So what I understand is that dependencies are going to be there.
Yes.
And they are going to increase as we move forward.
True.
So it's not about ending dependencies, it's about managing them.
Yes.
Is that the right understanding?
True. Yes, that's when I think IP comes into the factor.
Okay.
In managing those dependencies, because when it comes to IP, it can either amplify or either mitigate all of these dependencies depending on each of the scenario. By amplify, I mean today you can have exclusivity over your resources that you have come up with. You have, of course, your patent, your copyright that comes in, licensing that comes in. That would help to create those prominent players and exclusivity by amplifying IP. Secondly, you have IP mitigation that happens. The way IP can mitigate is, again, something that I own. I want to commercialize it. So I will commercialize it, of course, through the IP ways of having those collaborations, those licensing techniques, so that even I'm owning today after being the global player, and also at the same time the technology is getting access to the global market as in. So I would actually put it in such a nutshell that IP is the only way you can bring about a balance between the compute, which is the major dependency, and the data, which is your king at present. That's the only way IP can balance without bringing the exclusivity and accessibility issues.
Yeah, but having said that, one more important statement which you made is that these things are only available with, a few big
Yes.
companies. The big muscles are the only one who can manage effectively all of those.
Yes.
See, there are very limited number of companies doing that or are capable of doing that today. Does that mean that we have a big opportunity for others?
Yes, we do have a big opportunity, but it really depends on the companies how they are seeking those opportunities. They just go blind eye jumping into it. They will be running behind litigants. Because what is happening is when AI came in at a nascent stage, they came up with an approach of everything that is available, my model will use that. But now, as time is going by and the problems that is pricking in, you have certain behavior is as per someone else, the author is altogether someone else, you have someone else reaping those profits altogether. So with all of these coming in, which even the countries are actually still asking as to how to deal with each of these models, I really feel for our company to be one of the global companies, say, you have to have your IP in place, you need to have your laws in place, and then take the step ahead.
Okay,
So a careful plunge.
that's a very, very well said and well narrated response. So let's go back to Subbu. Subbu, I won't let you relax. Okay. But I won't trouble you also. But when we talk about IP and other things, there's something which goes hand in hand, sometimes follows is competition law. Okay. So competition law mainly will look into those aspects of IP like abuse of dominance, okay, a refusal to deal, or data access remedies. Okay. Now, do you think the existing competition law is, in the present form, is adequate to tackle the algorithmic trends arising in the current situation when we are looking for something like a systemic AI platform? So what are your views on it?
See, what AI has done over the years, it has challenged all our fundamental thinking. I mean, now we get into competition in all laws, whether it is a patent law, also you have seen the kind of. So when it comes to competition, what we should appreciate is the traditional foundation competition model, which is very relevant to AI also. I will first talk about the relevancy and next the way forward. The relevancy is it puts a control over dominance and antitrust and other kind of issues, which would allow, I would say, an arrogance of an investor when it comes to very high stake, high investment area like AI. See, look, all the big players have pumped in a lot of investment into it. And if you look at the market realities, the return on investment is there, but the expected return on investment is not as per the expectation. So that is why you would have seen companies like Nvidia and other big firms, their stock shot up during the AI wave, but it plateaued and it was not as much they felt it would go up. Of course, they did well, just because the shareholders' expectation on the returns was not up to the expectation. So with that comes a lot of pressure on them to able to reap their investments. In that process, there is dominance. And though the concepts of algorithmic rents and what we call as the system, so the challenge therefore is, how do you understand the foundation, appreciate, I would say, not understand, appreciate the foundation of the competition law and mold it to what today the AI requires. So the direction with which today our Indian competition law with the committees established to look at how it can be more of ex ante rather than after the event has happened, because that doesn't work in the case of AI, because by the time you would have seen the complexity of the technology, the damage is already done. So therefore, the concepts what Europe is thinking about, or many countries, why not I target this so-called big players and give them some kind of a check or a balance, and so that it will not stifle, as she was mentioning, the innovation pipeline. And also there is a domestic interest to make the domestic industry also survive. So it comes with all those kind of requirements, but nevertheless, in short, we should have, I would say, 3 different layers. One layer which is built strongly on the computation foundation, which is very strong. I think when we had the MRTP and to today when we are competition, the foundation is very strong, which controls and which regulates competition. But over that layer comes the layer 2, which is what we now call suited to the requirements of evolution of AI. Okay, so there probably this kind of algorithmic rents or some kind of watchdog mechanisms to make sure that these AI players do not over dominate or create a barrier for innovation. That is where the government regulatory practices or AI specific laws and would come into play, which has to be woven about this layer 1 of strong foundation. Then the layer 3, all the more vital, sector specific and country specific. Because as a nation, we are also investing and we want to also encourage our own generic AI models, players, startups. As we see in this hall also, there are quite a few of startups. So their interests have to be met. So that sector specific regulations would also have to be thought through. Net, the policy makers are in that direction, where they are trying to look at how these 3 layers can be well placed to suit their own domestic interest at first, and later on they'll have to see how they can make it a little more harmonized globally. I think that's the answer to that.
That's very aptly summed up. So, okay, with that, I'm very tempted to draw an analogy, Shivani. See, like with the telecom industry, okay, where there is a well-defined essentiality. We say something is essential and it has been defined. So we talk about SEPs. Ladies and gentlemen, SEPs means standard essential packets. So in the telecom industry, for essentiality and controlling SEPs, we have a contractual arrangement known as FRAND. Okay. FRAND, for those who are not familiar, is fair, reasonable, and non-discriminatory contract agreements. So Shivani, my question is, do you think that we should be looking at possibilities of developing a FRAND-like scenarios for AIs rather to stop or inhibit the development, the far reach effect? What are your thoughts on that?
As you very well explained, FRAND is fair, reasonable and non-discriminatory terms, and I truly believe there is a need for that, because just imagine if there is a bridge connecting 2 cities, and the owner of the bridge is charging a lot, maybe just even to cross that bridge. So that should also not happen. In that scenarios, then we should have regulators coming in. Of course, the companies owning the data, owning the model, they should charge, and they have the authority, and of course, in every means they can do that, but not at the cost of charging maybe 1 crore just to cross a bridge. So for that, we should have some regulatory bodies coming in the picture, regularizing all the FRAND thing for all these things under AI.
1 crore is too little.
I'm just
Someone will get you right now.
I'm just saying, for a crossing for a normal bridge, 1 crore is a big amount.
Unless you're talking in terms of dollars.
So yeah.
Okay, now coming back to the Krishna, that you talked in your previous response about big companies having some kind of processes. A follow-up thought which came up on those is that It is not only the large multinational AI companies, even some of the big domestic players uh, who are adapting to various strategies to handle their product and processes, leading to localization. Okay, localization of what? Localization of sovereign policies. For example, a requirement to train, host model locally, or use indigenous data sets. Do you think thus it's resulting in fragmentation, and or is it strengthening the pipeline?
Basically, currently there is like being a whole switch from what it used to be a global AI model to more of a jurisdiction-based AI models that's coming in. As per our previous discussions, there is now involvement of data that everyone is now alarmed about. With that coming in, all your sovereign policies get kicked in, where each of the countries want their local data to remain within their country. Now, in that scenarios, what are the steps that they are taking right now, or should be taking right now, is that a lot of these countries have now decided on keeping their data, especially some of them categorize the data and they keep based on the sector. If it is not something that is proprietary or sensitive in nature, then certain countries are okay with the data going out of the country. But otherwise, if they have regional data sets based models that are being made, they are making linguistic based data models. Based on that, they have been asking the trained AI models to come into their country, get the data that is of their country specific, inside the country only get it trained itself. So what is happening is that while we are utilizing the outside AI models, the data is still remaining in the country as such. That is what is mainly your data localization means, which I feel it is the right way of doing it. Like for example, we have India. India has got so many languages at bar. Now what is going to happen is that the AI global models that are being made outside, they are not going to be the language specific models that are in. And the reality is that it's not that everyone is well versed with English, right? Everyone has some or the other language barriers that come in, sorry. So that's when you have linguistic models being made here, that is the advantage. You can cater to the local market. So that's one of the reasons why you have countries even wanting to generate the models inside their country rather than going out of it. In this scenario, again, your IP being the best friend when it comes to data localization also, they would come into the picture of where licensing model works, because that's the only way this thing is going to function really very well, because you're utilizing someone else's IP into your own IP. So that's when IP is going to be bridging that gap between the two. So I feel in the long run, what is going to happen is currently it does look like somewhere it is leading to fragmentation, because obviously setting up your infrastructure as per the localized laws, leading and following the regulatory frameworks of every country obviously costs a lot at present. But when you're looking at a larger picture, you will eventually, when those infrastructures and those things start aiming out and giving you out, churning more money, you will have people coming in to invest in that, which is of course going to be at an advantage for that country. So it's a very long run process. However, it should not lead to what I call it as a data protectionism, where too much of restriction comes in from the country itself, where outsiders are not allowed or they cannot enter into it. For example, you have China. That is the best example of it. They not only churn their own AI models, they even have their own data that is not allowed to go out until and unless there's a proper scrutiny done by the country and by the authorities, because of which the foreign investors find it very difficult to enter into those countries. So I feel there should be a hybrid model between the globalization and localization that comes in, where your data and infrastructure remains in the country, and what is as such happening is a cross-border interoperability, where you have collaborations, licensing leading to it. So yes, that's my take on it.
Yeah, so you're basically suggesting a hybrid kind of situation which balances on whichever side the need is more at the
Yes.
moment, or at any other moment. The balance is dynamic, it may change.
Yes, they are
And
already.
we don't want something like, China is bureaucratic, or they see the political system, everything
Yeah,
is
yeah, they
different.
have a different way. But as I was discussing about how country specific everyone is working in, that's one of the China is opposite of what the other countries are doing at present. Hence, I picked up the advantage of China. I mean, example of China while describing on how each of the countries is dealing with their data locally. So, I came across one thing that India is being lately doing, which is actually a very good model, is that they are forming trusts. When it comes to, there is something called as data trust, which the state authorities, they form this authority or a regulatory body called the trust, and it's that entity that is entering into these agreements with the outside sovereign countries. So what is happening is that there is already scrutiny happening from that perspective. So they very strongly believe in like a give and take relationship. Today, if you are utilizing our data, we want that sort of an infrastructure, we want that sort of a model in return, which I feel is a very, very fair way of dealing with
That's a
it.
very fair ask.
Exactly, very fair ask. And then of course you have the normal, that is the escrow framework model, where you have the trained models that is coming into your country, very well trained ones with a clean slate, where there is nothing as such or no, I will say, a leeway left for your data to be leaked outside.
Yeah, because many of the large companies, even of the West, are seriously considering to open data centers in India now.
Yeah.
And work has already started.
Yes, your Reliance, which is one of the examples of biggest data centers that's coming in Jamnagar.
That's,
at present.
and I think, they are just in line with your thoughts on what you expressed.
Yes.
Okay, thank you so much. Okay, come back to you, Shubho. We're talking about sovereignty. Okay, sovereignty, if you look at it, there is data sovereignty, there's algorithmic sovereignty, and there's also IP sovereignty. Now, I guess they are not all of them are not same. And especially in countries like India or other low middle income countries who are trying to make indigenous models, as we've been discussing. What is your thought, for them, that will that in the long run avoid dependency, or it will just end up in a bunch of let's say territorial platforms?
So the way I look at and where our government is heading towards, looking at there is a trade-off between sovereignty and innovation. See, look, innovation requires a lot of deregulation, collaboration, less of policies, less of bottlenecks traditionally. Okay? Whereas sovereignty is required, especially in the concept of or in the AI pipeline, because as Professor Anindya mentioned, three different types of sovereignty we are discussing. A, data sovereignty. So like for example, as in India with such a huge population, let's say we are building an application to determine our disease prominence. Let's say we are targeting diabetes or any other disease which is quite prominent in India, wherein the data is coming from billions of people. So don't you think as a country like India, we would like to have the data sovereignty? But having said that, to make disease prediction and analysis, I would require the best models. So I want the best models from the world to work with my data. So wherein I must allow international players to be able to come to our country and work with our population and bring out what we require. So algorithmic, when it comes to when it comes to data sovereignty, some very strong points. I'm being very India specific. strong points emerge because of our diaspora, our population dynamics, etc. And by nature, we are having a lot of data, I would say, whether it is retail. But when it comes to algorithmic sovereignty, it's a trade-off. Okay? So we are not building all the models in our country. Neither we have built models which can, come in close race with what America or China. So when you there talk about algorithmic sovereignty, you end up shooting yourself, right? So there you'll have to have a trade-off. At the same time, when you give that kind of openness to allow innovation to come in, you will also have to safeguard your local and domestic interests. Okay. So thereby, I've seen some very intelligent moves done, like they pick up very specific projects, like public sector projects, where you say, I would allow my data to be used. At the same time, when you bring in a model, there are certain restrictions, or rather very smart restrictions, I would say, that you will allow knowledge transfer, you will allow interoperability. That means if somebody like our startup brings a model which can work in cohesion, so you allow that interoperability so that the domestic interests are met. And the third one would be what he spoke about, was the IP sovereignty. IP sovereignty again has to be carved out, I would say. So today in the earlier discussion also, we felt we cannot give a blanket kind of IP ownership to anyone. It has to be carved out based on inventorship. It has to be carved down on contractual basis. So as long as you have, and in India as a country, with our all laws in place and with all new practitioners around, we are evolving. So we have all the ammunition to be IP sovereign. But where we have to be cautious would be the algorithmic sovereignty, and data sovereignty and algorithmic sovereignty. You have to be very specific. Maybe you can distinguish between public sector projects and private sector projects. Net, the trade-off will be innovation versus sovereignty. So we can't have a slogan-based approach that I want to be sovereign. Yes, you have to be sovereign, but be selective, be strategic, allow domestic play, don't be too discriminatory, that I don't want any multinationals to come. That will also may not work. So net, I think that's what the government is today doing, and that's why we see a lot of growth in our country.
Thanks, I think with more focused approach to this, the growth factor is going to just accelerate and become bigger and bigger. Okay, Shivani, one small little thing is that while we are discussing this, there are many countries, many states which have both legs on two different boats. What I mean by that is that they strongly focus on data localization and sovereignty on one side, and the other side they are seeking access to global data sets. Now, having this practice is quite common nowadays. Now, if you look into this with this objective, first of all, is this a conflicting objective? Or aren't we enriching the entire digital mechanism by this?
True, you said that the states, the countries want data sovereignty, wherein they want to store the data locally, and also they want AI innovation. To solve that, of course, this is both contradict things, because you cannot, don't exchange the data and don't get them. So that is how it's worked, because ultimately to solve that, hence we have now DPDP. There is something called as DPAs, where you can, there are data processing agreements, where you can actually exchange the data. DPDP suggests there are certain countries which you can actually, exchange and send the data to for the processing point of view. So the innovation is not hampered. The data is sent to the legitimate countries what are suggested by the government. So that way also, if maybe there is a scenario, certain country is not mentioned under a DPDP, and we can't exchange or send the data, our data to them. In that case, maybe we can have the model implement in our local, like in that city, that country. That will also help in the AI innovation, and the data sovereignty will also maintain. To solve all of this problem, that's what I was, so previously when you were also mentioning, now we have DPAs in place. Every country can do, under the DPDP there are data processing agreements. You can actually do that and exchange the data for set period of time, maybe 6 months or like whatever that is. Also, if by doing that, we were talking about the contract part, who owns the data, the IP part, like the data person or the data company should have the IP as a, what I say, like a patent for that. But if we do it through a DPA, maybe the IP, the patent for the data company can be at least what we can say, just avoided. And of course the model, so model is the bigger picture, but solving all of those problems with the data sovereignty and AI innovation, I think this is the best way, taking in picture with the DPDP, our recent Data Protection Act.
Thank you, Shivani. Karishma, there's no panel, no discussion complete unless we make some noise about training.
Yes.
Training data.
True.
So let's make some, let's address this issue also. So in today's scenario, when we're looking at training data, whether it is web scrapped or user generated or licensed content, or how a company is structuring their mitigation strategies. Do they really want to indemnify, or they're looking for clean room data, or shifting to a federated data system? Like the guy who was presenting some service said that it's all their own federated data. Okay, so what do you think is happening, and what do you suggest as a good choice?
So earlier what used to happen is that the approach was whatever is available, frisk that data. Take that entire data, we will start working on our models. But as I said earlier also, with litigation and the problems mitigating now stepwise, the companies have become really very alert when it comes to model-based companies who are making models based on the data that is altogether of some other company. Their approach is now turned towards the question of where did you get the data from? Is the data that you have secured, is it somebody else's data? Is it your data? Because while the world is actually waiting from the judicial point of view to get those answers, it's really taking very long, is because it's not even their fault. With AI coming in, every step is new. In fact, I would actually say with AI coming in, we all have become students. Because what we have learned in the past, it's all adding to new genres that's coming in. So from a judicial point of view, it is of course getting difficult to lead to this current level of the changes that are happening. So what is happening is that generally when we have companies that approach us who have the data in place, they want an entire stepwise how we deal with the answers or questions that rather we are supposed to answer to the AI model-based companies. So what we do is that the first thing that we tell them is that you need to tier your entire data that comes into you. By tier there is something called as the data tiering. I'm sure the software people know about this, where your tier 1 data speaks about the data that the company owns itself. Then you have your second data, that is your proprietary data, or it belongs to somebody else altogether that you can get on license basis. Then you have got third, that is altogether data that you are unaware of, where there is a lot of risk while getting that data involved. So all of these data tiering happens to exactly know which level risk is your data currently right now is holding, which level are you in. Then second point is that you get your licenses in place. When you get an answer to where your data lies, you automatically realize, oh, this is some part of the data which I don't really own, but however so and so person owns that data. So what do is, you go and figure out where the owner is. After knowing where the data and who owns the data, you get the licenses in place so that you're legally sound from that perspective. Then the third step that you do is that indemnity, there is no escape. from indemnity now is because naturally when the AI model based companies are putting in that sort of a money, say for building in the infrastructure as how we were discussing about data localization, naturally they are not going to risk about that part. They are not going to take that headache of where the data generated from, how are we going to solve this litigation issue. So naturally at that point of time is the indemnity that comes into the picture, which every AI model company is asking for it, which I feel is not wrong at all. Then you have your clean state or the clean room data that comes from where you already know the source of data, where it is, that data is vetted, documented, and then started using the data. The another part of data that the companies look at is how synthetic data is, or can we use synthetic data. For people who don't know, synthetic data is a data that is a fake-based data. It's not that it's actually there present. It's just that it is taken on the basis of a real-world content, but the real-world content is not utilized while generating that data. However, it is, I would say, a risk reduction technique than a risk elimination, because still, in spite of using synthetic data, you still at times come to know that this data already belongs to somebody else. But that's one of the ways that the companies are dealing with. Another is your federated data, as we have spoken about that long enough, where the models are already trained in and they have sent to the local companies here, and the AI uses the local data and the data remains here. So what the AI takes back with them are just the learnings and not the data. That's how the federated data works. And lastly, what companies have been very specifically seeing is that they are not giving in to the technical disadvantage of what I call it as memorization of data. What happens is that while the AI model is working in, the data that they churn to get tends to memorize something that is already in existence. As we've been talking about, oh, this is the style of that author. The data is turned out like that. That's nothing but memorization. So the companies have started filtering their output also that comes in. So with all of these factors that they are putting in, they have somewhere tried reducing the risk towards inviting litigation. Let me put it that way.
Fine. Thank you. We just really like that statement that we've all become students.
Yes.
And then the moment, I think we should all remain students also. And that's how the learning never stops. Having said that, at the same point, I also feel that some of our curriculums needs to be updated from their current archaic form. So at this point, I would like to take a pause before we start talking again. This is an opportunity for the participants to ask any question about what we spoke, or in general the theme of the conference. So, is there any questions?
Hi, my name is Vishwas. My question is about so to give a background. So I work in a pharmaceutical industry. So where in general pharmaceutical industries, companies need to design around secondary patents like formulation or method of use patent. So with the advent of AI, I have seen a recent trend that companies who are providing AI-based solutions, they are filing IP on the wherever the secondary solution is available or alternate solution is available for the secondary patent. So this is creating impact of challenging situation for generic industries or biosimilar industry. So how do you think that what would be your thoughts on how biosimilar or generic industry can mitigate this challenge?
You want to answer or shall I answer?
Yeah.
Well, Vishwas,
I would expect it from Dr. Sarkar.
you have all wrong expectations. And then you call yourself that your name is Vishwas. Vishwas for Vishwasinera. Well, gentlemen, the situation is AI is just identifying an opportunity, okay, which can be done humanly as possible. You can sit with a bunch of or buckets of patent information. Look for those opportunities yourself. Now you have a tool which does that for you in much lesser time. Having got or identified an opportunity doesn't mean you can file a patent. Patent requires few other requirements. Okay? And those requirements of patentability would force you, more so in the pharma industry, to go for experimentation. So you develop, you do the experiments, reach a meaningful conclusion, and if that meets the criteria of patents, you can file a patent. Now, what is AI doing here? AI is just doing a job which is believed to be more comprehensive and accurate at a much less time. It's not that you can't do it, tell me. You can look at all those a few thousand documents and find an opportunity. It may take a few months. You're just identifying the opportunity. So when you say they are filing a patent, they cannot. Because that does not satisfy the conditions of patentability. It only identifies and points out an opportunity which could lead to proprietary IP. Does it answer your question?
Yeah, the scenario here is the small companies who are taking help of these AI-based solutions, and they are filing. So probably they might be doing some small experiments and generating data that can certainly meet the patentability requirements, and that could create. That's what now it is the next challenge biosimilar or generic industries will be.
What's wrong in that?
Yeah.
What's wrong in that? So you are looking for identifying areas of proprietary IP. Whether you do it in-house, okay, or hire a consultant like me, okay, or use a tool, how does it matter? Because you have to establish the conditions of patentability if you want to file and get a patent allowed. It doesn't matter if it's a small company or big company, he is not doing anything wrong. Unless, the tool is mischievous in nature. So you're using a wrong tool. Then comes, how the tool was trained and all that, blah, 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 which we were talking about. Okay. Do you have any other question?
Thank you.
Looks like we do not have, we have been explaining things so nicely that nobody has any gaps in their thought. Okay, fine. So before we end up, I'll ask all three of you for your 1 minute of closing remark.
As I said earlier, we go with the understanding and direction as to how we apply, whether it is an IP law, contractual law, regulatory law, and finally, not just look at legally defensive solution, but also commercially viable. I think that is what would make the innovation flourish, whether you look at a country-specific strategy or an industry-specific strategy. That is the direction which I feel we should take to see that AI meets its goal, and the goal is the societal benefits. So there we all come in as one of the key stakeholders, and we are the enablers.
So as we were here for discussing about the AI ownership. Whenever we talk about AI, it cannot go without data. So the data is the input. While talking about the ownership, we should also take into consideration the DPDP rules now, which are every company has to follow, because that will also solve a lot of problems, which every company really wants to solve, about the ownership, even getting a patent for the AI model and all of those things. A lot of things will be solved. So we have to we should be in sync with the data, privacy compliances and then deciding along with it the AI ownership, because these two things go hand in hand. That's what my closing line will be.
I would like to just say one thing, that with innovation coming every single day, how much ever you go to a brilliant consultant like any of us, or how much ever the laws are changing, there's always going to be that small little loophole that will or may come up with, because everybody is getting new to the whole structure. It is on you how you are going to take that loophole and convert it into an advantage towards you. For example, if you tomorrow find that, oh, I'm being using somebody else's data, you don't run towards litigation. Make that person also earn at the same time. Commercialize everything that you come across, how much ever viable the scenario is. There is licensing, there is collaboration, there are things that are already persisting. I would really suggest to always turn and look towards things that's already persisting, then to sit and wait, what do I do next, or what am I going to go through next, as everything is changing day in, day out. So yes, that's my closing.
I too get a chance to make a closing remark. So I thank the organizers for having us here, all of us, putting all of us together. I thank all my panelists for being such a wonderful session and sharing their valuable thoughts. And I also thank all the participants. You have been a wonderful audience. Thank you all. Have a wonderful day.
Thank you so much, everyone. Thank you so much. As we are talking about all of the students, I believe all are good students. We have all understood everything well, so there is no question. And as Professor Chaka said that of course you all have explained everything pretty well. And it's very increasingly clear that the future may not be shaped by those who innovate technology, those who kind of discover everything, but it is to be shaped by those who govern and protect the interests. So thank you so much. I would now request Dr. Reddy to come on stage to felicitate all of our speakers with mementos.
Thank you, sir.
Thank you. Thank you so much.
Thank you.